Good morning, Your Honors. My name is Carrie Sarah, and I'm here from the Shelby County Bar. I would like to reserve 5 minutes for rebuttal time. This case presents an important question regarding the circumstances under which a third party can waive an individual patient's right to a jury trial. The trial court in this case correctly treated the healthcare power of attorney at issue like every other contract in the state and examined the capacity of the principal to convey the authority to the healthcare agent to sign the defendant's arbitration contract. 346208 of the Durable Healthcare Power of Attorney Act, and also a similar provision in the Healthcare Decisions Act at 1810, does not prevent this court from examining a principal's capacity to contract. If it does, then those statutes violate federal law and impinge upon Section 2 of the FAA. The Court of Appeals in this case, in rendering its decision, exceeded its scope of review by creating its own argument to overturn the trial court when it applied the Healthcare Decisions Act to find that an agency relationship existed where none otherwise would have. So we ask the court's ruling, the trial court's ruling, to be affirmed in this matter and the Court of Appeals to be reversed.
Mr. Sarah, the Court of Appeals didn't address an issue that wasn't before it. They just applied different law to the issue. Is that right?
That is right.
But should they be required to apply the, I mean, do you think that they applied the wrong statute?
I do. And I think the court's analysis in Barbie versus Kindred lays out why. The court, well, let's start with this. The defendants conceded, as well as the plaintiff at the trial court level, that the Healthcare Decisions Act didn't apply. So there's no question that the parties had agreed that wasn't applicable. The Court of Appeals reached to over...
But is a court bound by what the parties agreed to?
No, certainly not.
For example, the parties couldn't, agree that an erroneous standard of review applies. Yeah. Would you agree with that?
Yes, I would. But I think what's important is what Your Honor wrote in State versus Bristol, that the lower courts should adhere to a party presentation principle so that all of the parties have the ability to properly brief and argue an issue that is raised. So if the Court of Appeals wants to address a new statute, as it did in this circumstance, at the very least, the parties should have been afforded an ability to brief it and perhaps argue it. And if I may say, this is the problem with the court's analysis, among other things. It didn't really speak to Section 1806 of the Healthcare Decisions Act, which is the applicable provision when a patient lacks the capacity to grant authority to appoint its own healthcare agent.
Let me probe a little bit. I can agree with you that I wish the Court of Appeals had posed to the parties, what about this more recent statute? Brief that for us.
Say that again, Your Honor. I'm sorry, I didn't catch the...
I wish that the Court of Appeals also had said, what about the Healthcare Decisions Act? Sure. Brief that for us before they had written their opinion. But you are before us now.
Yes.
And have full opportunity to address why that's the right framework or the wrong framework. When you were asked, is that the wrong statute? You said yes, but I'm not sure that I heard a clear answer why. I really want to hear that. Substantively, is that the right framework? It seems that it would be the correct statute to apply. And
maybe I ought to reword the answer there. I meant in the sense of it had not been applied correctly in this circumstance. If we accept the proposition that David Welch lacked the capacity to contract, okay, which if we start there, then the court would apply the Healthcare Decisions Act, Section 1806, to an incapacitated individual. And the sections within that provision lay out a statutory framework by which a designated physician, and only a designated physician, to appoint an agent. The designated physician in that circumstance has to examine the principal, determine that they lack capacity, then examine statutory factors for selecting a healthcare surrogate who would have the best interest in mind for the principal. And then that designated physician has to denote such appointment and why within the medical record. Those things didn't occur here, and I think that's what the parties agree on, is that didn't occur here.
Well, can we just look at, let's see, I guess I'm looking at here, section 34.6.217C,
Okay?
which is the provision that says a durable power of attorney for healthcare, and I'm omitting some things here for sake of brevity, that does not evidence an intent that it is entered into under this part, being the Healthcare Decisions Act, may, if it complies with that act, be given effect as an advance directive. Now, I read that as being permissive. In other words, a court may apply the Healthcare Decisions Act in that situation, but I mean, the Court of Appeals seemed to treat it as mandatory, that unless there was a contrary intent that that a durable power of attorney entered into after a certain point in time must be evaluated under the Healthcare Decisions Act. Is that your understanding of the Court of Appeals opinion? Do you agree with that? Is there, I mean, I'm just trying to make, kind of fit what the Court of Appeals did
Yes.
with the actual statutory language, and no one seems to have really addressed that language.
Yeah, to be frank, I found the Court of Appeals decision a bit muddled on the issues and conflating some terms, and I think the analysis appropriate for this case would be to apply the terms of the FAA, which is what the arbitration contract says to do. And if you do so, then the normal contract defenses are available to a party to oppose an arbitration contract, because those arbitration contracts have to be put on the same footing. So I think it may be a distinction without a difference, because in this circumstance, whether we're dealing with a Healthcare Power of Attorney Act, whether we're dealing with a Healthcare Decisions Act, it makes no difference. Mr. Welch had no capacity to execute the contract at issue, the Healthcare Power of Attorney, and
Well, maybe it doesn't make a difference from your standpoint, because you feel like we arrive at the same result either way, but it makes a difference to me. If I'm interpreting statutory language, I got to know which statute that I am looking at. And Justice Campbell asked you a question, whether it's permissive in this kind of situation to apply the Healthcare Decisions Act, and I need to know the answer to it, because I'm going to be looking at the statutory language and interpreting it, and I'm not going to look at both of them. I'm going to pick one and interpret that.
And I guess from my perspective, it also bears on, we have this threshold question of whether the Court of Appeals exceeded its authority even by applying this statute where the parties hadn't argued that it was applicable. Sure. And, I think the way I look at it, if this were in fact the law that had to be applied, I don't really see that necessarily as reaching out and deciding an issue that the parties hadn't raised. It's just applying the correct law. But if it's permissive, if the HCDA is permissive as to whether that statute applies rather than mandatory, then in my view, the Court of Appeals did exceed its authority by applying that statute that the parties had not argued was applicable. So it's an important question for me as well, and I would like to hear your answer.
Fair, and I did not mean to dismiss it. I think the end result is the same as Justice Kirby hit on. But I think in this circumstance, you have a Healthcare Power of Attorney Act that doesn't, if you don't have the capacity to contract, I don't think that immunity provision excuses that lack of capacity to contract.
Well, I'm just talking about, I guess if we can look at section 217C, this is the provision that.
Yes.
Yeah, so, what in that statute requires a court to apply the HCDA to a durable power of attorney entered into
I
after
don't
that statute
believe
was
it,
enacted.
it does. What I think the analysis would be is that we determine whether we have a contract under the Healthcare Power of Attorney Act to figure out applying basic contract defenses. Is there a contract? If there is not, and we're dealing with a healthcare decision, then I do think it would be proper to turn to the Healthcare Decisions Act to see, are those provisions satisfied regarding appointment and designation of a healthcare agent within it, which did not happen here. And that's where the parties are prejudiced, I think, by the Court of Appeals raising a new statute because we weren't given the opportunity to brief it and say, Judge, I think you missed Section 1806 and the applicability of that in this circumstance. So I think that's where I come down on it.
Okay, and so just to clarify your position on whether,
I'm sorry, I'm
no,
not.
that's okay.
Yeah.
I realize there's a lot going on here.
There's a lot.
But just to kind of pin you down on, whether the HCDA actually was the applicable law. Is your answer to that no?
I think the HDCA would be applied once the Healthcare Power of Attorney Act was determined not to apply, that we wouldn't have a contract under that act. Then I think you apply the provisions of the HDCA to see, is the agent then properly appointed? In this case, no. So that would be the analysis. I think if you find the Healthcare Power of Attorney Act doesn't apply, then you go to the Healthcare Decisions Act, and then it fails. The contract fails. Same result.
What statutory language are you relying on for that transition?
Well, it would be the facts. It would be what the Healthcare Decision Act says under Section
I'm asking what
1806.
statutory language you're relying on.
The statutory language I'm relying on is that of Section 1806 regarding the application of an appointment, how you can appoint a healthcare surrogate when someone is incapacitated. And so
you're relying on language in the Healthcare Decisions Act.
for the proposition that that's when it would be applied, if we have an agent without if you have a principal without a properly appointed agent, which we say is this case, then you would default to the Healthcare Decisions Act to see, okay, this is the because it lays it out right there. If you have a person that lacks capacity and they have no agent, then this is how you appoint an agent. And those are the provisions that aren't satisfied.
Okay. Counsel, can you discuss the sentence in footnote 4 of Owens that
Yes.
says discovery should not be permitted concerning the validity of the power of attorney or the circumstances surrounding its execution?
Yes, Your Honor. That footnote 4 in Owens, it's important to learn when it was added. It was added after the first petition for rehearing. And before the U.S. Supreme Court decisions in Kindred versus Clark and Morgan versus Sundance. Both of those decisions from the U.S. Supreme Court clarified that arbitration contracts are to be on the same footing as other contracts. Unfortunately, the footnote 4 in Owens, without having the benefit of those two opinions, it created more confusion for the bench and the bar than providing guidance. And so we've asked, and we've joined in the Court of Appeals invitation to this court to clarify this footnote and to hopefully explain that in this circumstance, if the healthcare powers of attorney are treated differently than the other contracts, and you can't examine a principal's capacity to enter into it, then you are in essence favoring arbitration contracts by applying a law in a manner that results in the denial of the normal contractual defenses to authorize the entry into an arbitration contract. So, I think the timing of the Owens footnote and I think the two subsequent U.S. Supreme Court opinions really do explain why we should have a different result and why we would ask this court to clarify that footnote for us.
And would it be fair to say this would be dicta, this sentence in footnote 4?
I think footnote 4 is dicta because of the timing of its addition. It's a first petition for rehearing upon which at the time that it was added.
But how is it dicta if it constrained, it it had an effect on what the trial court could and could not do.
I think it's akin to something that was discussed by this court in State versus Walls, and when dicta is controlling and when it's not. And I think the dicta in that case was determined to be controlling because it gave guidance to the bench and bar of the inferior court. In this court, I think that was this case, it was the intent to give everybody guidance. The problem was it created a lot of confusion.
Well, I can see it's got no reasoning, no
Right.
nothing.
There's no discussion.
But it's probably, in my view, it's probably a misnomer to call it dicta, because it actually had an effect. It wasn't just, but,
Is that in effect today?
yeah.
So that's fair. So maybe I should say it's not controlling. I wasn't sure when I read it either.
But it was just, kind of
Right. No analysis.
put out there with no reasoning, no nothing.
But you're
Right.
asking us to overrule it. I mean, to the extent it is controlling,
I am.
you're asking us to overrule it.
Yes, I'm asking you to overrule it, to change it. That's,
Typically,
you can do
a
that.
new rule or a new law isn't put in the middle of a footnote at the end, that's
Yeah.
not typically where we would place a new pronouncement of law.
On rehearing
On
particularly.
rehearing, yeah.
Yeah, it was a tough place. It shocked all of us that were involved in that case, let's say.
Can I go back to
hope I can
your
answer.
transition from, please don't go back to that, but I'm
I
sorry,
don't-
I'm stuck
I'm afraid
on
I
it
don't
a
have a
little bit.
satisfactory answer.
You've focused on Section 1806 of the Healthcare
Yes.
Decisions Act, which goes through the whole procedure for the physician to appoint somebody to represent somebody who doesn't have capacity, all that.
That's right.
I understand your argument on that, but nominally, the ward here had an agent. There was a document executed, and so why aren't we interpreting it under Section 1810? You're saying it wasn't validly done, I guess, under that procedure but he did have an agent, at least according to the power of attorney, right?
Well, according to the power of attorney, and I think that's the difficulty in what I'm trying to argue or articulate to the court. I don't start with the premise that there's a validly formed healthcare power of attorney.
I totally get that.
Sure. Here, and I think on the face, it would have seemed like there was an agent appointed, if there was any good faith to rely on the document. But I think once the contract is invalidated, if you apply typical contract principles and invalidate the contract as a result of the incapacity, then it's like that document doesn't exist. There is no agent. And I think that's what takes us to then, if you're dealing with an incapacitated individual, we go to 1806.
Okay.
And see if that's adhered to.
Okay.
And while we're here, let's talk about that. In the lower courts in Hendricks, in Barbie, the court in Owens, everybody acknowledges that an agency is only created by the act of a principal. And the limited circumstances under which that you would have a different result with a person with incapacity would be an appointment under the 1806 or something more involved with the court, both involving presentation of some medical proof about the person's capacity or lack thereof before any rights were taken away from that individual or given to anyone else to act on their behalf. And that didn't happen here. There's no act, the record demonstrates, there's no real act by David to appoint an agent. He did affix his signature to the document when he was asked to by his brother. Yes, sir. But other than that, there's nothing in the record to indicate he asked his brother to do anything for him, that he asked for a healthcare power of attorney, that he was able to do that. It was his brother that took it upon himself to get to print off the healthcare power of attorney off the internet. His brother filled out the terms in the document. The brother chose this power of attorney because it did not require a notary, someone who may have more of a statutory obligation to check for capacity. He picked it because it only had spots for 2 witnesses to sign. And if you read the record very carefully, he actually indicates that he printed it off, had the witnesses sign it, and then presented it to David. And there's no proof that the witnesses were even present at that point. David was not even told what he was being asked to sign. So there wasn't a reading of the document to him. There's no evidence of that. There's no evidence that anybody even said, are you okay with your brother handling your decisions? That was not discussed. It was just somebody put an X there and said, sign your name. So I don't think that that is an act of the principle that would lead to an agency relationship. You know, to the extent the court needs to hear it and understand, I think the trial court was correct in its findings that David lacked capacity. You know, he'd lived in a home for the mentally disabled, intellectually disabled for 28 years. He was described as having no ability to learn. He couldn't see, he couldn't hear, he couldn't speak well, he was barely understandable. He had rudimentary decision-making abilities that may have, like a child, where he may have been able to say, you know, to agree to getting a shot in his arm that moment if somebody's there to give him a shot, just like my kid would. You know, same thing, same analysis. But I think what the Bador Center records show us is a gentleman who, leading up, especially to the execution of the purported power of attorney, he had experienced very childlike behaviors that were only getting worse as we got towards January of 2012, where the power of attorney was signed by him. So I think a good case, a very helpful case for this court to consider if you're examining the capacity of David in this circumstance would be to look at the Tennessee Supreme Court case of Knight versus Lancaster, which involved an intellectually disabled man who had a 9-year-old mentation. He worked. He was able to work. He was able to drive. He took care of himself. He could wash his own clothes and feed himself. All things that David did not have the capacity to do. The gentleman never lived on his own in his whole life. He required constant supervision. So I think that Knight versus Lancaster will show this court, I hope, that the plaintiff has carried their burden in this case to show he lacked the capacity to enter into the contract at issue. And I do want to hit that real quick if we can. This is the healthcare power of attorney at issue was a complex transaction. It wasn't as simple as, you can do for me, brother, thank you. It was a 4-page, single-spaced document involving at least 5 different decisions that had to be made. He had to decide on an agent, an alternate agent, the scope of authority, the effectiveness of the agreement, when it becomes effective, and who he'd want to nominate as a guardian. David didn't fill out a stitch of that. He didn't answer a single question about that. He wasn't asked a single question about that, and I would posit it's because he wouldn't have understood it. So like the intellectually disabled man in the Knight case, Mr. Welch could not reasonably understand the transaction at issue or the consequences thereof. He had a lifelong disability with no significant improvement. I think the plaintiffs carried their burden there. So we would just simply ask the court to apply the principles that are espoused by the U.S. Supreme Court in Morgan and Clark, and not devise a special rule in this case to favor arbitration and enforce this contract. The court should treat this healthcare power of attorney just like every other contract in the state and examine the capacity of the principal to execute it. The court should not stretch the plain language of 208's immunity provision or 1810's comparable immunity provision to enforce a contract that's otherwise unenforceable. We haven't talked about that provision a whole lot, but...
Well, I guess I have a question on that
Yes.
point. I mean, do we even need to get to the, potential conflict with the Federal Arbitration Act? If we find
No.
that, that these provisions, whether we're looking at the durable power of attorney, healthcare durable power of attorney statute or the Healthcare Decisions Act, that the language of those so-called immunity provisions just don't cover this situation, then we don't even have to reach any potential conflict
That's
with
right.
the Federal Arbitration Act. Is that right?
That's right, you nailed it. I don't think you ever get to these statutes violating the FAA because in their application here, they clearly, by the plain language of the statute, apply to transactions that expose a healthcare provider to civil, criminal, or professional liability, right? The part of the statute that wasn't quoted in the footnote. And here, there's nothing about a forum selection contract that would expose the defendants to any kind of civil or criminal liability. To the contrary, they represent, when in a paper that they is affixed to the arbitration agreement, that just by signing this agreement, we still owe the same exact obligations to David to provide care within the standard of care. So those immunity provisions are simply inapplicable, and if you treat this contract like every other contract, then I think it fails because the healthcare power of attorney fails for want of capacity. So thank you, Your Honors. We'd ask that the trial court be affirmed. Thank you. And I'm going to see if I can find a good answer for y'all when I come back. So. Thank you.
Good morning. May it please the court, I'm Christy Kreider, and I'm here on behalf of the appellee, Christian Care. Christian Care respectfully requests that this court uphold the finding of the Court of Appeals that Christian Care Center, a healthcare provider, was entitled to rely in good faith on a facially valid healthcare power of attorney document executed in conjunction with David's admission to Christian Care.
Ms. Kreider, go ahead.
Was it really in good faith if they bring a man in who can't see or hear or take care of himself at all? Did anybody really think he knew what he was signing when he signed that, just as a practical matter?
Your Honor, the Court of Appeals analysis of that is instructive. The Court of Appeals recognize that, first of all, the document itself is facially valid.
Right.
It meets the requirements, whether analyzed under Title 68 or Title 32, whether under the Healthcare Decisions Act or under the Durable Healthcare Power of Attorney Act. James presented to admit David as his brother. James had been operating under that healthcare power of attorney document for more than 4 years. It was executed.
Does that matter if it was not signed by someone who even knew what he was signing? Or what if it had been forged? Would the analysis be the same?
I think that the answer to your question is yes. And the reason that it matters that they had been operating under it from January of 2012 until November of 2016, at the time of this admission, is looking at the pattern of the number of healthcare providers who had also relied in good faith on this healthcare power of attorney. Let's start with the first,
How does
Your
that
Honor.
matter, though? What if he had signed this, this had been prepared and signed the morning of his admission? Would your argument be any different?
Well, I wouldn't have 4 years and 10 months of other healthcare providers seeing this document and also relying in it on good faith as evidence that when Christian Care Center relied on it, they were in good company with a number of other healthcare providers. Allow me to give you a few examples.
May I back up a second? I understood you to answer Justice Lee's question. It would not matter if that document had been forged. Did I understand you right?
Well, the legislature chose to include protections in both of the statutes we're analyzing against forgeries. Let's look at what those are. The legislature chose to include in both statutes that it must be signed in writing with either a notary present signing or 2 witnesses with required attestation language. So the legislature chose to put protections in place against imposters. If we
So
look
what if
to,
it had been forged? What if it had been forged? What difference would that have made?
if the document had been forged, then that would mean that 2 witnesses had perjurized themselves,
Okay.
disinterested witnesses who had known David for a very long time.
what
So
if
that
they did?
protection is in place. And if it had been forged, I think part of what we also need to look at here, and it's part of what the Zoka court's analysis was, is it is okay for this court to look at David's decision that he made about which healthcare, who he wanted to make his healthcare provide decisions for him in determining whether this is likely a valid document that was not forged.
But
The
what if it
evidence
was-
is
What
that-
if it had been forged? Let's just assume for a moment the brother signed the brother's name, and 2 witnesses signed before the forgery took place, and they had no idea who was going to sign it, but the brother ended up signing the disabled brother's name. Would your argument be the same here, that we cannot look beyond the face of the document?
It would be, Your Honor, because first of all, it is in the legislature's discretion to determine whether immunity will not apply. And the legislature...
Let's talk about that a little bit, because I think to determine what situation, in what situations the legislature determined immunity should apply, we have to look at the statute. Would you agree with that?
I agree, Your Honor.
So we've got 208, 346208, and then 6811, 1810 as the 2 potentially applicable immunity decisions. So we won't get into which one applies at this point, because I think, would you agree that they are, for present purposes, materially similar?
I agree.
Okay. So can you point me, I guess, to the language in one or both of those provisions that provides immunity in this situation? I mean, what you're arguing is that your client should not be subjected to litigating in a judicial forum because there was an arbitration agreement entered into based on this durable power of attorney. So you're saying they should have been able to rely just on that this was a valid document, and as a result of that, they should be able to avoid litigating in a judicial forum. So what in these statutes gives you immunity in those situations? I mean, I'm specifically looking at, if we look at 208, it says a healthcare provider is not subject to criminal prosecution, civil liability, or professional disciplinary action. Is your client being subjected to any of those things?
I would answer your question as follows. I think there are 4 instructive things that we should look at in analyzing whether James's decision to sign this arbitration agreement, cloaked with a facially valid healthcare power of attorney, subjects a healthcare provider to civil liability under the immunity statute that Your Honor has referenced that is materially similar in both acts. The first thing that I would ask the court to consider is this court's decision in Owens, which addressed this very issue, interpreted this very language, and reached the very conclusion that Christian Care Centers is asking this court to reach again.
Let me follow up, because I'm not, I want to hear the answer to Justice Campbell's question, and I think that we are veering off. I want to hear the language in, let's say it's the Healthcare Decisions Act, 1810. This gives civil immunity to your client for complying with a healthcare decision by the agent if you have a facially valid document. I can see how that works. If the document is a do not resuscitate order, then your client would have, say, withheld life-saving care for somebody and refrain from giving them that care in reliance on the do not resuscitate order. This is an arbitration provision, and it was not required, was it, to admit David to your client's facility?
It was
right?
not.
So where's the reliance on a health care decision under the language of the statute? I've been struggling with that.
I understand. And Your Honor, the reason I was veering into Owens is because I thought there was some reasoning there that was instructive on the interpretation. And I think to answer your question directly, it is protection from immunity from civil liability, that language in the statute. Now, how do you get there? How do you jump from...
For civil liability for complying with the healthcare decision of James.
Right, so the way that we get there from the civil liability from complying with the healthcare decision that James made on David's behalf is we start with the statute. And the statute says if there's a facially valid healthcare power of attorney and a healthcare provider relies on it in good faith.
I just
that
want to
they-
know the healthcare decision that was complied with by
Well,
James.
The Owens court decided that the decision to enter into an arbitration agreement as part of an admission to a nursing home would be considered by the court.
A healthcare decision, I understand that. But how is your client subjected to civil liability for complying with a healthcare decision by James?
As Your Honor noted in your questioning of my opposing counsel, there's not a lot of reasoning in the Owens decision as to how they reached that conclusion. We know that this court did reach that conclusion in Owens.
I want to know your reasoning. There's no reasoning in Owens. I want to know your reasoning.
My reasoning is the reasoning that the Owens court applied in determining that a healthcare decision maker could enter into a legal arbitration agreement on behalf of their principal, which also at first blush might seem like a bit of a leap. And the Owens court's reasoning on that decision, I think, is very instructive on the court's decision today. And that is that this court decided.
Was there any healthcare decision made by your client?
According to this.
Any healthcare decision that James made that your client is seeking civil immunity from?
Yes, Your Honor.
What was that?
The decision to enter into the arbitration agreement on behalf of his principal.
But that's not the basis on which any sort of civil damages are being sought in this case. It's not the decision to enter the arbitration agreement. I mean, you can agree that I think the situation the legislature had in mind here is the one that, of the sort that Justice Kirby posited, where there's a do not resuscitate order or some other actual healthcare act that the healthcare provider needs to perform, based on a directive by someone who holds a durable power of attorney. Would you agree with that?
Yes, if I may answer that in two ways. The first is the reasoning in Owens in deciding that a healthcare decision maker can enter into a legal arbitration agreement, which doesn't seem at first blush to sound like a healthcare decision, is because this court in Owens said we are going to look at the transaction as a whole. And the transaction as a whole is the decision to admit David into a healthcare facility. And what was the reasoning that this court gave us in Owens for deciding to look at that decision as a whole rather than slicing out the arbitration agreement for, as Justice Kirby pointed out, the DNR, which is so clearly a healthcare decision. And what the reasoning of this court was in Owens is that it is, and the word this court used was untenable. It is untenable to take a large transaction of admitting someone into a healthcare facility and then slice out some parts of the decisions that are made in conjunction with that and call those healthcare decisions.
Just to clarify, so I'm not disputing, I guess, the part of Owens that says this is a healthcare decision. What I'm looking for in your answer is the link. What is the link between that healthcare decision? If we agree that entering into an arbitration agreement in the healthcare context is a healthcare decision. So what is the link between that decision and your client being potentially subject to civil liability, which is what this immunity provision would provide protection from?
The link is, as Justice Kirby pointed out, there is one part of this transaction, the execution of the DNR, for instance, that if they rely upon that in good faith and James, the agent, comes back later and disavows himself of his authority more than 4 years later, as he did here, that could potentially be a civil action for them treating without consent.
But the arbitration agreement does not impose civil, there's no, all that does is determine the forum in which it will be determined whether your client has civil liability. You're not relying on it. You didn't do or not do anything in reliance on it. The only thing an arbitration agreement does is when somebody files a complaint, you pull it out of your back pocket and say, we have to arbitrate this. You didn't do or not do anything in reliance on it.
Your Honor, in reliance on the agreement being valid, the healthcare power of attorney being valid, Christian Care permitted James to sign all of the admission paperwork on David's behalf. And what this court instructed us in Owens is that we should treat that transaction as a whole. And
But
not
his admission into the facility was not conditioned on execution of the arbitration agreement.
It was not conditioned, and this court and the Court of Appeals have found multiple times in cases subsequent to Owens relying on it that even optional arbitration agreements entered into with nursing homes on admission will also be considered healthcare decisions.
Sure.
Even if it is not required, as Your Honor pointed out in this case. And if I may get to the second half of your question, which is your
I've already
reference.
forgotten the second half. Remind me what that was.
I'm trying to remember, which is us looking to determine what the legislature's intent was. And I believe, Justice Campbell, that in your question, you referenced that it's pretty clear that the legislature's intent is to protect from things like improper consents to treat or battery or those types of things that might come up. I think it's important to remember in this case that we have been operating under the Owens decision from this court for 15 years now. For 15 years, we have had stare decisis and settled expectations in place that discovery would not take place surrounding the execution of the healthcare power of attorney document to determine if the principal had capacity. The Owens court was very, very intentional in taking that issue up on a petition to rehear when it denied the petition to rehear in other matters. The court was very intentional in amending that opinion to add that very clear instruction. And I believe that both Justice Lee and Justice Bivens, in your questioning of opposing counsel, pointed out that it's found in a footnote. And that's not normally where we look to new controlling precedent. And I wanted to point, Your Honors, to an opinion from our United States Supreme Court. It's called United States versus Donato, decided in 2009 by Chief Justice Roberts, and Justices Scalia, Thomas, and Alito joined in on that decision. And in that opinion, the United States Supreme Court was relying entirely on the precedent found in a footnote, and fortuitously, it was footnote number 4. And in footnote referring to that, our United States Supreme Court said, the authority the court cites for this key jurisdictional analysis is a footnote. Now, footnotes are part of an opinion too, even if not the most likely place to look for a key jurisdictional ruling. But since footnote 4 plays such an indispensable role in the majority's analysis, it must be read with care. And I would commend to this court that just as our United States Supreme Court read footnote 4 of a different statute with care in order to find its presidential value, that this court should do the same thing with the footnote number 4 in Owens. And why is stare
We can still read it with care and still overrule it.
You can decide to overrule it, Your Honor. This court can decide that that court got it wrong 15 years ago. But I'd like to offer you a reason this court should not do that. And that is the legislative inaction doctrine. And this court and our Court of Appeals has long recognized the legislative inaction doctrine. And in fact, the seminal case where it's really interpreted was authored by Justice Kirby in 2017, and that is the Hardy versus Tournament Players Club at Southwind case. And in that case, the court analyzed in detail the legislative inaction doctrine, and what that doctrine stands for is the proposition that if this court or another appellate court interprets one of its statutes, and the legislature is presumed under that doctrine to know of the interpretation of this court of its statutes. And if the
But actually, the legislature acted. They enacted a whole new act, the Healthcare Decisions Act.
They did, although that was 3 years before this decision in Owens. But that being said, Your Honor, under the legislative inaction doctrine, we presume that the legislature knows of this court's interpretation of their statutes, and we presume under this doctrine, which I will point out to the court, as Justice Kirby did in the opinion, it's not a rule of law, but it is a judicial principle that you are permitted to follow. And in that judicial principle, it says that presumption will be that the legislature agrees with this court's interpretation of their statute. But then the opinion goes on to give us additional instructional information. And that is that if the legislature makes amendments to the statute that was interpreted after the opinion and does not change the section that the
Assume that the legislature was aware of a footnote that was added after a petition to rehear.
Not under the legislative inaction doctrine. It has precedential value. It was a very clear instruction. It was recognized
But
and
the
quoted.
Healthcare Decisions Act, I mean, it just wholesale supplants the prior act.
Well-
It's just a complete, it's a different structure. I mean, it was a huge transformation. It's hard for me to connect the dots there.
I will connect those. Before I do, if I may, I
Yes.
wanted to let you know that the Healthcare Power of Attorney Act has been amended twice since the Owens decision. In July of 2013 and July in 2015. And the court did not disturb the immunity provision.
Well, do we have to
Second-
equate civil liability with arbitration to get to where you need to be here?
Yes.
So you're saying arbitration is equal to civil liability under the language of the statute?
Yes, because that is what this court said in Owens.
Well, the court didn't say that in Owens. I mean, the court really didn't provide any analysis in Owens of why it was giving the directive that it was,
Well,
did
the
it?
court specifically cited to the immunity provision. It gave a specific citation in the footnote to the immunity provision and said, based on this provision, there will not be discovery at the trial court surrounding the execution of the healthcare power of attorney. So I think this court did give a very clear instruction.
Well, it gave a clear instruction, but it didn't give reason. It didn't
I would agree
explain
with
why
that.
it was reaching that conclusion.
I would agree that it gave no reasoning for that, Your
And it
Honor.
may be wrong, and if it's wrong, we have an obligation to reverse a precedent that is incorrect. or
If
out
you
of
have,
date.
yes, Your Honor, if you have misinterpreted the legislature's intent and misinterpreted the plain language of the statute, then there is a mechanism to reverse your prior ruling. I would also like to add, before I get back to your question on those two statutes, that the healthcare...
You are very good at keeping this stuff in your head. I much respect to you for that.
The last two things, or the last thing I wanted to add on the legislative inaction doctrine is that the Healthcare Decisions Act has also been amended 3 times since the Owens decision was handed down, in 2011, 2013, and 2014. So 5 total times that the legislature has looked at those 2 statutes since Owens and did not disturb the opinions. In candor, 3 of those times were fixing grammatical things, but 2 of those things were substantive amendments to the statutes. Now, getting back to your question, Justice Kirby, about whether the Healthcare Decisions Act supplanted the Tennessee Healthcare Power of Attorney Act, it did not.
Okay.
The Healthcare Power of Attorney Act specifically stayed in place exactly as it was written with the addition of an amendment to the end of the act. And the amendment at the end of that act is found at 1803J. And it specifically says that if there is a healthcare power of attorney that complies, I'm sorry, I quoted you to the Healthcare Decisions Act. I'm going to go back and quote you to the Healthcare Power of Attorney Act, which provides at a specific reference to the Healthcare Decisions Act. And it says, a durable power of a healthcare entered into after July the 1st of 04, which is the date that the Healthcare Decisions Act was passed, that does not evidence an intent that it is entered into under this part.
It's 217C, the provision that Justice Campbell
That's right.
referenced before.
May, and it uses the operative word may,
Okay.
be interpreted under the Healthcare Decisions Act. Likewise, the Tennessee Healthcare Decisions Act specifically references the Durable Power of Attorney for Healthcare Act and has the same language. Why? Why would the legislature choose to include this continuing scheme of healthcare decision-making rather than just repeal the original act and replace it?
So I take it that you would you agree then that, I guess where there's no intent evident about, what law the parties intended to govern, that application of the Healthcare Decisions Act is permissive and not mandatory?
I do agree with that, and I know that that affects your decision, as you stated, to opposing counsel. What I would like to point out on that, Your Honor, is that I think that the parties were correct in interpreting this under the statute that we originally interpreted under. I also think we would have been absolutely correct to interpret it under the Tennessee Healthcare Decisions Act. And the reason that Christian Care interpreted it under the Tennessee Healthcare Power of Attorney Act is because Owens had already specifically addressed that act, and that was the issue there. And so what the Court of Appeals did was extend this to the Tennessee Healthcare Decisions Act, which was permissible for them to do, as it was appropriately analyzed under either act.
Well, if you were approaching it anew, and we didn't have this issue of the Court of Appeals verging beyond the statute that the parties had argued before it and not giving you a chance to brief it, just looking at it fresh, which act do you think controls and which act should we be construing?
Pursuant to the terms of the legislature chose to make it permissive for the party executing it to find, or the court evaluating it, or the healthcare provider attempting to evaluate it. The legislature's stated purpose was, we want to ease up the restrictions on Tennesseans being able to appoint a healthcare agent. The requirements for a competent individual to appoint their own agent are essentially identical under the two acts. Where the second act, the Healthcare Decisions Act, varies greatly from the first act is if you're attempting to appoint a surrogate for an incompetent. And that is not the case here.
So am I understanding you to say that really the provision that we should be construing is TCA 346208A? Is that correct?
Your Honor, I don't think that the Court of Appeals was out of the scope of its authority in analyzing this under the Tennessee Healthcare Decisions Act. I think the legislature gave this healthcare provider, the Court of Appeals, and this court the discretion to analyze it under either act. And in my remaining minute, I might briefly add, since we haven't gotten to the issue of whether the Court of Appeals was outside the scope of its review, which Justice Kirby, you articulated as important to you, and I understand why, is that under Tennessee Rule of Appellate Procedure 13B, appellate courts generally do not address new issues on appeal, but it is perfectly permissible for courts of appeal to apply additional law to an issue that has already been raised.
Ms. Crider, before you get, as you're running out of short time, I want to switch gears real quickly and go back to something you said that kind of stuck with me at the beginning of your argument. You were talking about the fact that this power of attorney had been relied upon for 4 years in making various health care decisions. Your client didn't know that at the time it entered into the agreement, did it? That's because that was just came out during discovery in this case, correct?
Well, Your Honor, they could have seen the date on the healthcare power of attorney and known that it had been in place.
They did not know at the time they entered into the agreement that that had happened, that had been, it could have never been used in the 4 years, correct?
That's correct. That's absolutely correct. And when I was making that point, Justice Bivens, that was in response to whether they acted in good faith and the evidence.
Well, I understand, but how does it impact a good faith decision if they didn't know it to begin with?
It doesn't go to their mental state. It goes to the fact that multiple other healthcare providers reached the same conclusion that my client reached.
That they may not have known that. And it was certainly to your client's advantage that day to accept that power of attorney, because that came with an admission of that patient and obviously financial benefit to your client to accept that.
I agree, Justice Lee, and it was also a huge benefit to David. It was a huge benefit to David because for more than 4 years, David and James had enjoyed the benefit of James being able to help David secure life-saving health care. He had secured cataract surgery for him with this document. He had secured bone anchoring hearing aid surgery for him. He had secured 2 hospitalizations for him. For more than 4 years, David and James enjoyed the benefits of this power of attorney, just as our legislature intended.
Okay, thank you, Ms. Crider.
Oh, thank you very much, Your Honor. Am I out of time?
Yes.
Okay.
You were answering questions, that's fine.
Thank you very much.
Well, Your Honors, I have an answer, but Ms. Crider stole my thunder. No, that's exactly right, that Section 217C of the Healthcare Power of Attorney Act permits a durable healthcare power of attorney that doesn't evidence its intent to be entered into under this part, which is this power of attorney, permissively may, if it complies with the Healthcare Decisions Act, be given the effect of an advance directive. And I think that's what we don't have. We don't have compliance with the Healthcare Decisions Act, and we don't have a properly formed healthcare power of attorney. So that's the problem. This contract fails.
Sorry, I know your time on rebuttal is short, but I do want to ask a little bit more about overruling Owens. Ms. Crider pointed out that, it's been the law for some time now, and typically, before the court overrules a precedent, one of the things we consider is our reliance interests and kind of what the effect of overruling the decision would be on the parties in a particular area of the law. Can you just address that? Are there reliance interests that we should be considering here?
No, and the reason is because of that immunity provision that we're arguing about. If a defendant has in fact relied upon someone that they thought was a healthcare agent for someone, and they engage in some transaction that puts them at risk, like providing surgery where you needed informed consent, that immunity provision then kicks in and helps in that circumstance and says, no, it's okay that you provided that care. You thought this person was the agent, so long as they had a good faith basis, which in this circumstance, we challenge. And so that's the issue, It doesn't mean, though, that by granting immunity to a healthcare provider for relying on someone they thought by an agent somehow creates that agency relationship. It's the opposite. In the Barbie case, it was acknowledged there that there's a custom with healthcare providers where they have to rely, and often do rely, on next of kin to make healthcare decisions for an incapacitated individual. Not every person that doesn't have adequate mentation in this state has a properly appointed agent, for many reasons. That's part of the reason the Healthcare Decisions Act was enacted, was to help with that process. But if you have an incapacitated individual, you have to afford them the same exact protections, the same exact contractual defenses that that you would afford a capacitated individual. And that's why in this circumstance, we're saying it doesn't make the contract any more valid when it's executed by an incapacitated person. And if you want to designate an agent for an incapacitated person, the Healthcare Decisions Act helps us and gives us a mechanism by which to do it, or a court procedure would do that. And both of those things involve an assessment by a physician, an analysis of the person to determine whether the individual lacks capacity or not. So I think that's the issue. And Owens just wasn't reasoned. I mean, this court can do whatever it wants. It can fix its prior opinions. And Justice Holder, when she wrote that, she didn't have the benefit of those opinions that we have now from the U.S. Supreme Court that give us some direction about how to treat these contracts. And we can't go out of our way to apply state laws to raise, to favor arbitration contracts or to disfavor them. That's what the Supreme Court was dealing with in Kindred versus Clark. They said the Kentucky clear language rule where you had to expressly say you wanted to agree to arbitration, they said, no, that favors arbitrations when you apply that law. The same would be true here. If you apply 208 in that way, you are going, it disfavors in that circumstance. In this case, it's like the doppelganger of Clark. If you apply a state law, you're going to be elevating arbitration contracts by applying a state law and enforcing them in a situation they're not otherwise enforceable. And just on, it may not be worth mentioning, but the Donato case and the Hardy case that Ms. Kreider talked about, the legislative inaction doctrine, those things weren't briefed, I don't believe, or cited. I don't think it would change the court's analysis or result in this case for the reasons we cited earlier. The court's case in Walls, the court's case in Bristol. You've told us when a court can properly espouse dicta, or a court of appeals can properly raise a new issue. And in this case, we're not asking you to do any of that. We're asking you not to create a special rule to enforce this contract, and instead to protect David's rights as an incapacitated individual to designate agents. Thank you, Your Honors.
Thank you both for those excellent arguments. We're going to adjourn until 1 o'clock.
Please all rise.